Good afternoon, members. I call Committee of the Whole on Bill 17, Police Amendment Act 2024 to order. We are on Clause 80. Shall Clause 80 pass? Recognizing the member from Prince George Mackenzie.
Oh, thank you, Chair. No, clause. I'm still struggling with the broad definition of the laws of an Indigenous governing body. So this is prescribing a law enforcement a designated policing unit, the ability to enforce the bylaws of a municipality or a regional district and the laws of an Indigenous government body or other laws, and I'll get into that as well. And part and parcel with this, the other part of this says the care and custody of supervision of persons held in a place of detention. So to me, this is pretty heady stuff. So the definition of Indigenous governing body means an entity that is authorized to act on behalf of Indigenous peoples that hold rights recognized and affirmed by Section 35 of the Constitution Act 1982, which every First Nations in the province and across Canada is entitled to. They still fall under this umbrella. So this is a broad definition. I'm just trying to find out what these laws are. Where are they, and how do we gain access to them?
Minister.
Thank you, Honourable Chair, and I appreciate the question from the member, and hopefully this will add some clarity and comfort for the member. So this section is a regulatory power-making section. To be able to use this section, it would have to come by regulation. A regulation would be required, so that means it would have to be by cabinet. The regulation would have to identify the specific Indigenous governing body, and it would also have to specify the specific law that they wish to have enforced. So it could not, nothing could be done unless it was authorized through regulation, specific to a particular Indigenous governing body, and a specific law that they would wish to enforce. That's the only way that this could be used.
Member.
Thank you, Chair. I certainly understand that. I guess what I'm concerned with, so it's in a regulation and it pertains to Part 1 or 1406 or whatever that, where it laid all this out earlier. And I understand that part of it as well. But I have trouble with an Indigenous governing body, very broad statement, in enforcing the laws of an Indigenous governing body. So I'm wondering if the minister could give me an example of the laws of an Indigenous governing body that are outside of the ability already with police to deal with bylaws that are duly constituted under the Indian Act, and any that might pertain to a treaty that also have been duly constituted.
Minister.
Thank you, Honourable Chair. For further clarification, so this section does not apply to municipal policing, doesn't apply to provincial policing. It only applies to designated policing units or DLUs, designated law enforcement units. So first, there would have to be the creation of a DPU if an Indigenous governing body wanted to create, first that would have to happen. Then the regulation would have to be prescribed, saying this is the law that you can enforce, and that's it. Like, you can't enforce anything else other than that. And it would give them the authority to do that, because sometimes, even now, there's not necessarily, there's hesitancy in terms of around authority. So this clarifies that.
Recognizing the member from Skeena.
Thank you, Honourable Chair, and to the Minister through the Chair. I've always struggled with this definition, Indigenous governing body, because the definition really speaks to Aboriginal rights and title and the representation of that, which is totally separate from the law. Canada's laws, BC laws, and we make that distinction in treaty negotiations, whether we're talking about Tsawwassen or Niska, for example. But the problem I have with it is because when you're talking about somebody that's representative to speak on behalf of the communal right of Aboriginal title, we haven't fully defined that either. In most respects, we're really talking about councils who are legal entities. They're codified with Canada, they're codified with BC. It's a legal entity that actually understands their liability and responsibility as being elected by the people. I'd go as far to say they haven't even addressed the idea of the ability of an elected council to represent Aboriginals in title. I think it's a question that still has to be answered for many band councils. And for that question to be answered, not just for elected councils, but for non-profit societies that tend to represent Aboriginals in title on behalf of communities. I do question how non-profit societies came to that representation, because Aboriginal rights and title is a communal right. So only stands to reason that the members of that band should have had some type of process to delegate whichever authority it is to represent their Aboriginal rights and title. But never have I seen any organization representing rights and title saying that they have the right to represent their rights and title in a legal aspect when we're talking about the laws of BC and Canada, except for treaty negotiations. And that's where it's explicit. So can the minister explain to me, when you're talking about the representation of Aboriginal rights and title, are we including the non-profit societies and maybe even individuals that purport to represent rights and title currently, as we're seeing today?
Minister.
Thank you, Honourable Chair, and I thank the member for the question. And the answer would be no, no to societies, no to individuals. The meaning is that in the future, other Indigenous governing bodies may have lawmaking authority as a result of an agreement, legislation, or a court case. And that's how it's intended to work.
Member.
Thank you, Honourable Chair, and thank you to the Minister for that question. So I presume for the purposes of liability and safety and well-being of not only Aboriginals but non-Aboriginals as well, but also for the liability of Indigenous governing bodies and the provincial government, there will be a process to determine who represents the rights and title, unless the government's considering changing the definition specific for this bill, because the definition of IGB is pretty broad and pretty specific to representing rights and title, which I can see that in terms of maybe some rights and title considerations, consultation, accommodation considerations in terms of the resource industry, but I can't see it applying to how does it exist beside Canadian and provincial laws, especially when you've already told treaty nations like Niska and Tuasin and other treaty bands that the paramountcy of laws must exist. It has to exist. And these treaty bands have already agreed to that. They've said, yes, we will not create our own laws. We'll abide by speeding laws, murder laws, stealing laws, and all that. We won't take on that responsibility. We'll leave that out Canada, BC. So I'm going to ask the minister, is there a process to determine who represents the First Nation in this respect, in terms of who has got the right to speak on behalf of the First Nations? And is it still going to be based on the idea that it's First Nations First Nation bodies who represent the rights and title of their communities.
Minister.
Thank you, Honorable Chair, and I appreciate the question from the member. So if an entity approached us and said that they wanted to establish a designated policing unit or a designated law enforcement unit, we would first consult with Ministry of Indigenous Relations and Reconciliation to confirm if the entity has the authority to speak on behalf of the rights holders. That would be the process.
Member.
Thank you, Honorable Chair. And so I assume, I haven't seen it written down anywhere, what is the process to determine whether or not a body has the right to speak on behalf of Aboriginal rights and title holders, which is actually not only communities, but in my mind, band membership lists. So it doesn't just have to be a community. But if there is a process, I would love to see what process that is to determine who has that right. Another question is, once you determine that there is authority to speak on Aboriginal rights and title, and I assume this is going to get bumped over to the other ministry as well, but I'd like to ask it here. How is the government planning to deal with overlapping rights and title claims? Because in some cases, there's like 10 or 12 First Nations that are actually claiming all the same territory. So you'll have to figure out, how do you give one lawmaking authority, which is almost saying, you're almost making a decision to say, yeah, this is your territory, and almost disregarding the overlap participants.
Minister.
Thank you, Honorable Chair. And so, as I mentioned a moment ago, we would first, be consulting and working with Ministry of Indigenous Relations and Reconciliation. And what you're talking about, if those things could not be resolved, there'd be nothing would happen from within my ministry.
Member.
Thank you, Honorable Chair, and thank you to the Minister. That's actually a pretty good answer. It's a tough topic, believe me. First-hand experience. But anyway, it's Aboriginal rights and title is a really complicated topic. I mean, I've been studying it for 20 years, and I still don't have a clear line on what it is. I know what it isn't, but trying to interpret the case law is probably the hardest part. But in terms of this is actually a benefit, for lack of a better word, that will be afforded to First Nations bands who have Aboriginal rights and title. And I'm assuming this is undefined title, asserted title. But we have bands in BC that have defined title. We've got Tawasin, we've got Niska, Manold. So if the government does carry through with this and does make it to the point where it's actually coming out in regulations, and you're giving the bands that benefit of lawmaking authority, what I'm going to presume is parallel to or within the paramountcy rules of Canada and BC, which is actually included in the treaties of BC, then Niska will have that right to that same benefit. Any benefits that go above and beyond the Niska Treaty, for example, that exceed Niska provisions, Niska has that right to go after that same benefit. If the government does follow through this, and it will pass, I'm presuming, then Niska will have to they'll have the decision to make. Do we go back and include this in our treaty? If that is what the Niska decide to do, or Tsawwassen decide to do, you're going to have to open up a constitutionally protected document. And that's Canada, BC, and the First Nation. And so it won't end there. And we already seen the constitutional document opened up already for Tsawwassen, for example, for the reserve tax exemption status. That was extended to Niska. This is the same thing, but this is a lot bigger issue because we're really talking about the laws of BC and Canada. And not really much detail in terms of where that's going to land. But in terms of opening up the constitutionally protected document to afford this benefit to Niska and Tsawwassen, for example, is the government pursuing a plan on how to communicate this added benefit to Niska and other treaty nations?
Minister.
Thank you, Honourable Chair, and I appreciate the question from the member. So in terms of Nishka, I'm pretty sure they do, and I will confirm that for the member. The other modern treaty nations that the member referenced already have that power in their treaties to to create a DPU, a designated policing unit, or a designated law enforcement unit. That's already there, but I'll confirm for the member on Nishka.
Recognizing the member from Prince George Mackenzie.
Thank you, Chair. And I realize under the previous discussions we had that these modern treaties do have that authority as an entity to do that. This would be a separate, this would be an entity prescribed, is from what I understand, because a lot of the existing First Nations communities don't have, you know, aren't a recognized entity unto themselves as per the definition under 1401 or whatever that was at the beginning there. So, but I am curious, still curious. The minister did mention that the lawmaking for the laws of indigenous governing bodies would be either through agreement, legislation, or court decision. And I understand, so just clarification on each one of those issues. Agreement, like as a government, we're going to give you the right to make a law. You know, what does that look like? Legislation, is that according to the Indian Act and bylaws that a band or a duly elected band council can pass? Or how does that apply to a indigenous governing body when they may not be elected perhaps? So how do they comply with Indian Act requirements? And then the third definition was court decisions. Maybe you can enlighten me on that as well.
Minister.
Thank you, thank you, Honourable Chair. And I will deal with them in no particular order. I think first in terms of the court decision, I think that's pretty straightforward. Court says that's the court decision, and province, you know, has to follow that decision. The other two, in terms of legislation, you'd be talking something like the Indian Act, for example, if there was, you know, something done through the Indian Act. And then in terms of agreements, I think you'd be looking at, you know, primarily like treaty agreements or a tripartite agreement involving the federal government, the province, and the entity, the nation or the entity. I think that would be what's meant by those three things that the member talked about or asked about.
Member.
Oh, thank you, Chair. Appreciate the answer. I guess I'm looking for, you know, a court decision comes out and says the province must do this, amend legislation or whatever the case it is, and there's a process that makes sure that it's still constitutionally valid as a law of Canada under the Constitution, the Supreme Law of Canada. Legislation, yes, the same way. You know, we're working on this particular piece right now, so there's a process to make sure that it's constitutionally valid as well. The agreement, you know, we have a treaty agreement, we have different agreements in place. that, you know, where some kind of authority will be bestowed upon an Indigenous governing body, is that authority going to afford them the ability to make an enforceable law? I guess that's what it's all about, is an enforceable law that will be covered as a designated policing unit.
Minister.
Thank you, Honourable Chair. The short answer, Honourable Member, would be that Cabinet would never pass a law that is not enforceable by regulation. So,
Member.
Thank you, Chair. I'm sure Cabinet would never dream of doing something like that, and I'm sure that all the people behind the minister and in the hidden offices of the legislature drafting folks will ensure that never happens. But this infers that the laws of an Indigenous governing body. To me, that indicates that perhaps the governing body, Indigenous governing body, will be making up laws and asking this designated policing unit to enforce them in a designated area. Is this what this section is saying?
Minister.
thank you, Honourable Chair. And I appreciate the question from the member. So every law would have to take its ultimate authority from the Constitution. And it would still have to, obviously, as I said, it would come to Cabinet through regulation, and it would have to be specified for the area. It would have to be specified exactly what law, what the law is that could be enforced. Other than that, nothing can happen.
Member.
Thank you, Chair. So that leads to a different paradigm here for me. The laws of an Indigenous governing body then, from the answer that the minister just gave, would be the laws of British Columbia, basically, or the laws of Canada. So I'm just wondering whether it's even necessary to include the laws of an Indigenous governing body.
Minister.
Thank you, Honourable Chair, and I thank the member for the question. So I think the answer to the member's thing is that Indigenous laws are not considered laws of British Columbia.
Member.
Thank you, Chair. Well, that's interesting. So would they be, so what is an Indigenous law then that the minister is referring to that is not a law of British Columbia?
Minister.
Thank you, Honourable Chair. It would be treaty laws, for example, or it could be band council laws.
Member.
Thank you, Chair. So those are the laws of British Columbia or the laws of Canada. So they're part of that milieu of laws that enforcement officers have access to when they're enforcing laws on First Nations lands or territories, along with the laws of general application that police generally follow. So we're talking about a designated policing unit enforcing Indigenous governing bodies law. So, this is substantial from my perspective because this indicates that they're enforcing a law. So people will be held to account to obey whatever these laws are. What kind of process does the policing officer have or use in enforcing that law? What, under the laws of the natural laws of justice, everybody has an opportunity to stand up to it and ask for a hearing. Who interprets this law? Where is it written down? All the rigor that the Charter requires to be put into a law in order for somebody to enforce it and to be answerable to it as well.
Thank you, Honourable Chair. All of those, thank you. All of those things the member just raised would have to be considered and in place before anything could even happen in terms of what was wanting to be done in terms of a law or the creation of a DPU allowing to do around a particular law. All of those things would have to be addressed.
Member.
Thank you, Chair. So maybe we're making progress, maybe not. But so the laws of an Indigenous corporation or governing body rather indicate that the laws are there. And so, it's talking about the enforcement of bylaws of a municipality or regional district. Those are in place. We know they're duly constituted. The laws of an Indigenous governing body, I'm not familiar with the laws of an Indigenous governing body and how they are developed and constituted and who is in, who maintains the level of scrutiny over those laws. Would they be required to be passed through the provincial legislation in order to be approved, or do First Nations governing bodies approve them themselves?
Minister.
Thank you, Honourable Chair. Perhaps I'll give a couple of examples as to how it works. Because as I said, all of those things have to happen before anything could even come forward to Cabinet. And two examples, Tawasin, for example, they go through hearings, they go through proper council meetings, they go through proper procedures. It's all on the website, so it's there for everyone to see. It's there for police to see. It's there, right there. It would be the same for an Indigenous governing entity. They would have to go through that kind of process. In the same way, band council resolutions and bylaws are developed. They have to go through a proper process, and all of that stuff has to happen before anything could even be considered at the provincial level.
Member.
Thank you, Chair. So I guess what has put me in the direction that I've been questioning on is the definition of Indigenous governing body, an entity that is authorized to act on behalf of Indigenous peoples that hold rights recognized and affirmed by Section 35 of the Constitution Act. Again, that's pretty broad. So if this is the laws of an Indigenous governing body, a little more clarity would be the laws of a band council or First Nations community governing group or whatever. Laws of a First Nations Indigenous governing body, I think is pretty broad, and it indicates that perhaps an Indigenous governing body could just develop their own laws outside of the provincial area. So I'm comforted somewhat by the minister's answer on that, and I'll carry on. But it's still not. It's still something I have trouble with the way it's laid out in this particular regulation. The other area that I just need clarity on is the laws of an Indigenous governing body or other laws. Is that other Indigenous law, or is that other provincial law or federal law?
Thank you, Honourable Chair. Provincial and federal laws.
Member.
Thank you, Chair. And the other section here is subsection B, the care, custody, or supervision of persons held in a place of detention. So when I read this and I read the laws of an Indigenous governing body, to me that's a significant thing where they're taking somebody's constitutional right, charter rights away, and they're placing them in custody. That's a very high level of requirement in any kind of legislation. So, so that's what I was thinking about when I was looking at that particular statute, and the fact that this particular regulation does not talk about criminal law. So it talks about bylaws, and then the laws of an Indigenous governing body, and then people in custody. So not very many bylaws have a arrest provision. Some do, very few. Again, my awareness is pretty high with the way this is particularly worded. Now, because it's still under Clause 80, we can probably go to 74.2 sub C, where it talks about the powers, duties, and functions of a designated law enforcement unit and its enforcement officers, chief officer and deputy chief officer, including, without limitation, regulations that do any of the following. Prescribe any parts of BC that you're going to do that in. Prescribe the law enforcement services that may be provided, including without limitation in relation to the enforcement of the criminal law, the laws of British Columbia, the bylaws of a municipality or regional district, or the laws of an Indigenous governing body, and the maintenance, law and order, and the care and custody of prisoners. So this is a full-scale law enforcement or police unit, where you enforce all the laws. So again, I can take comfort with this definition in here that the laws of a Indigenous governing body will be duly constituted laws under the provincial legislation, that will be passed through the House and providing authority to this particular Indigenous group to have this law within their community, or it will be a duly incorporated law under Section 88.1, the passing a band council resolution, that it will be a law that the band council has duly looked at and has gone through first, second, third reading in the same process that we all do to bring these laws about. So I just need some comfort that we're going to see that in here.
Minister.
Thank you, Honourable Chair. Could you reframe it, because we're kind of, let's put it this way, dumb it down for me.
Member.
No, and I appreciate, sometimes I can get a little bit jumbled in my questions as well. So the way laws are constituted in British Columbia are, that are enforceable, particularly when we're talking about the criminal code. This is pretty significant stuff, and we're taking people's freedoms away. So I'm looking for the Indigenous governing body that the way they bring these laws forward is through the same process that we would use in a municipality where they create a bylaw where it goes through first and second and third reading. It's debated amongst the band council themselves, and once it's passed, the bylaw is created. Then it has to go to Ottawa to be approved under the Indian Act, under Section 88.1 or whatever, I can't remember exactly what it is. That gives me some comfort that that level is done. Or ask the province to enact a law under whatever legislation is, whatever statute is required, an amendment to a statute to have that governing body have that law applicable to them, so that it can be enforced as well. So I just want some substance around this section to know that these are duly constituted laws.
Minister.
Thank you, Honourable Chair, and I hope this, my response to the member answers the member's question. So, for example, the treaty process outlines the process by which the nation will make the law, so it spells it out. So that's how it takes place.
Member.
Well, thank you, Chair. But we're talking about Indigenous governing bodies that could be outside of a treaty. So we have Treaty 8, we've got TWAS, and we've got Niska, we've got different regions, but most of the province is not covered by a treaty. We have 204 nations in British Columbia. Most of them aren't covered by any sort of a treaty, but they could still fall into the definition of Indigenous governing body. So how would they develop their own laws?
Minister.
Thank you, Honourable Chair, and I appreciate the member's question. And hopefully this will answer it for him. So right now, there are only two ways, treaty and Indian Act, to do what the member's been talking about. The Act is written in a way to recognize the potential for future Indigenous governing bodies that have valid lawmaking authority. And so, in the future, there may be ways, and that's why it's written this way. But the key is that would have to have valid lawmaking authority. And right now, there's only two, treaty or Indian Act.
Member.
Thank you, Chair, and appreciate that answer. It does clarify it somewhat, which goes to, we could have saved a whole bunch of discussion going back and forth here if that had been part of the enforcement of the criminal law, the laws of British Columbia, the bylaws of municipality, or Indigenous governing bodies with valid lawmaking authority would clarify that. And, maybe the minister would consider an amendment putting that in there to provide me with some comfort, or provide people of British Columbia with some comfort as well. Because going with that goes, who has the authority to do this when it comes to the Narcosley Band in Fort St. James, the Clahasden Band just north of Fort St. James, the Yukuchi Band, but they're all part of Carrie-Sakani. So who would be making the laws? Would it be the band council for Narcosley, or for Yukuchi, for Clahasden, for Takla, or Carrier-Sakani?
Minister.
Thank you, Honourable Chair. And just a clarification for the member's question. So when this is the way it's drafted, you asked about the term valid law. The drafters, when they use the term law, they mean valid. They mean valid law and authority. So.
Member.
Thank you, Chair, and I appreciate that. There's no such thing as putting something in there without assuming that, I guess. But a lot of people, when they read this, are going to say, and the laws of an Indigenous governing body, well, what is that? Where are they? We know what criminal law is, we know what bylaws are, we know what municipal laws are. So I will go on and from that. And there's a couple of other questions I have in this section. Subsection III under 74.1, it talks about exempt the designated policing unit, designated constables, chief officers, or deputy chief officers in whole or in part from a power, duty, or function under Division 1 of Part 3. Now, I'm just wondering why this particular section is here. If these individuals are out enforcing the law and doing it with good faith, there needs to be some protection in liabilities, some pushback, whatever it might be. So I haven't seen that before, the way it's written. So.
Minister.
Thank you, Honourable Chair. So this section is designed to deal with designating policing services that don't provide boots on the ground service, but are operational, such as OCA.
Member.
Thank you, Chair. And I see that same clause is under the law enforcement, designated law enforcement unit. So, so that only, basically, this doesn't apply to the actual accredited police officers enforcing the law itself. This applies to support staff.
Minister.
Thank you, Honourable Chair. No, it wouldn't apply to support staff.
Member.
Oh, thank you, Chair. So it does say limit the powers, duties, or immunities that enforcement officers would otherwise have under section 14.5. So we hire enforcement officers and then we take their power away from them?
Minister.
Thank you, Honourable Chair. So, yeah, the member's correct that 14.15 provides the powers a member would normally need. But then section 74.2 enables those powers to be tailored for specialized enforcement duties.
Member.
Thank you, Chair. So specialized enforcement duties, so an enforcement officer comes fully accredited from the Justice Institute, and a lot of his powers, or her powers, or their powers, could be diminished or changed. So you'd have a fully accredited police officer, but you'd put them in another role with less responsibilities, or would you hire somebody that is not a fully accredited enforcement officer and do that?
Minister.
Thank you, Honorable Chair. So enforcement officers are not police officers. There's a difference there. And you would hire based on what's required. And so this would then allow for the powers to be tailored to the role that they are in fact fulfilling.
Member.
Thank you, Chair. So this section says, it talks about the powers, duties, and functions of a designated law enforcement unit and its enforcement officers. Chief officer, deputy chief officers, including without limitation regulations that do any of the following. So they're appointed under this particular section. They're referred to as enforcement officers. So there's a variety of levels of enforcement officers then that you would hire an enforcement officer to carry a gun and take people's authorities away, and an enforcement officer that is not trained to that same standard?
Minister.
Thank you, Honorable Chair. So yes, there could be different categories in terms of enforcement officers, but enforcement officers are not permitted to carry guns. Only police are allowed to carry, guns.
Member.
Thank you, Chair. So this section deals with enforcement officers. Power, duties, and functions of a designated law enforcement unit and its enforcement officers. Prescribe the law enforcement services that they may need to be provided, the enforcement of the criminal law, the laws of British Columbia, the bylaws of the municipality, et cetera, et cetera. So this reads to me that an enforcement officer is a police officer that carries a gun. The designated policing unit is where they're only doing the bylaws of the regional district and the municipality, but the criminal law doesn't show that it's included there. So, and the reason I'm spending some time on this is because I've seen situations where police officers, enforcement officers can get into a pile of trouble just doing their due diligence work, and they need the protections that's provided by this stuff that's being taken away from them.
Minister.
Thank you, Honorable Chair, and hopefully this helps the member. So designated policing units, what they can do is outlined in 1406. They don't need a regulation. So unless regulations provide otherwise, a designated policing unit has, under the direction of the designated policing board, the following powers, duties, and functions. A, to enforce in the designated policing area the criminal law and the laws of British Columbia. B, to generally maintain law and order in the designated policing area. And C, to prevent crime in the designated policing area. 2, in addition to the powers, duties, and functions described in subsection 1, a designated policing unit has the powers, duties, and functions set out in the regulations.
Member.
Thank you, Chair. So in our first discussions that we were speaking to under 74.1, it talks about designated policing units. And it's got that same subsection. So exempt the designated policing unit, designated constable, chief officers, or deputy officers in whole or in part from a power, duty, or function under Division 1 of Part 3.1. So it's in both sides. It's under the designating policing unit, and it's under the designated law enforcement unit. So I'm a little bit confused here. We've got a policing unit, the law enforcement unit, and the designation or the ability to take away their protection is in both of those areas.
Minister.
Thank you, Honorable Chair. So designated policing unit has all the ability to do all the things that we just talked about. They can carry a firearm. Designated law enforcement unit, a DLU, they cannot carry a firearm.
Member.
So thank you, Chair. Again, back to my question then, a designated policing unit has this exemption included in there. So exempt the designated policing unit, designated constable, chief officers, or deputy chief officers in whole or in part from a power, duty, or function under Division 1 of Part 3. So I'm just trying to find out why that's there.
Minister.
Hopefully we get it there this time. So it allows, and the example I will use is OCA. And so they're designated policing unit, but it allows them to be exempted from all of those things or some of those things that are in there, because they're not operational boots on the ground DPD.
At this time, I'm going to call a 5-minute recess for the committee. Call Committee of the Whole on Bill 18, Police Amendment Act 2024 on and back to order. We are on Clause 80. Noting the member from Prince George Mackenzie.
So just to sum up, the laws of a Indigenous governing body, the minister is, with that statement and that definition under the Act for Indigenous governing body, that implies that all the laws that this body will be responsible for are duly constituted under the Constitution of Canada and through the rigorous lawmaking process that we have, where it's first, second reading, either at the municipal level, the regional district level, or the band council level, or it's approved by a band council resolution through Section 88 of the Indian Act, and those are the laws that this is referring to and nothing else.
Minister.
Thank you, Honorable Chair. So I think I've outlined the ways in which valid laws can be enacted through that process that we've talked about. And I can tell you the province would not allow the formation of a DPO to enact in any way, shape, or form laws that were not through a valid authority.
Member.
Thank you, Chair. So just so I'm trying to balance things out here, and before we move forward with this. So if it was band councils, duly elected band councils that were processing a bylaw or performing a function as a duly elected governing body, is one thing. But if we have maybe we have a hereditary body that says that they are the governing body, and we have councils that are in the mix that say they are the governing body, and we have individuals that are individual KO holders within a territory who say they are the governing body over a particular KO or their traditional territory. That's where I'm having the trouble because of such a broad definition for this, that it basically, and I know where the minister is saying that they wouldn't let anything go by, but the interpretation of the act in front of me says that it's open to all these different entities, and I would like to see something a little tighter on that.
Minister.
Thank you, Honorable Chair. And really what I can say, and I understand the member's question, and it really comes down to, is it the two ways we have today, treaty or band, and in the future, there may be the formation that comes through the mechanisms I've talked about, through agreement or legislation or court. And I've also, I think, made clear in terms of the issues that the member from Skeena has raised around those things, that what would, before it even gets to me as Solicitor General, that all of those things would have to be resolved through MER, coming to us, to my ministry then, to be able to say, to take something to cabinet, to create the formation of a DPU that had a specific regulatory function or specific regulatory power to enforce a specific particular law. And so that's the best I can tell the member at this point.
Member.
Thank you, Chair. I guess, I probably just have to get it through my thick head. I'm familiar with regional district processes and municipal processes and provincial processes to create and enact valid, constitutionally valid laws. I'm familiar with how band councils, resolutions, and bylaws work as well. So, this broad term in front of me is just probably perhaps the reader of a statute like this has to have faith in the system, is sort of the way I'm taking it. And it's not entirely crystal clear to me that this won't be a problem in the future the way this is worded. So we'll leave that. Yeah.
See, thank you, Minister, most kind. Seeing no further questions, shall Clause 80 pass?
Nay, but on division. So I'm just.
Clause 80 passes on division. Shall Clause 81 pass?
Aye.
Shall Clause 82 pass? Shall Clause 83 pass? On Clause 83, member from Prince George Mackenzie.
Thank you, Chair. Just one question on this clause. No, more than one question on this clause. Exempting a council of a municipality from section 30.2 sub 3, the prohibition respecting detention guard duties. What conditions would the Lieutenant Governor be considering in order to exempt a municipality from this particular one?
Minister.
Thank you, Honorable Chair. So the short answer is some municipal detachments operate out of federally owned facilities, and that's why the exemption, that's why the potential exemption is there.
Member.
Thank you, Chair. And I can understand that for sure. It also talks about, for the purpose of section 30.3, safety officers, prescribing persons or bodies as safety officer employers, including without limitations prescribing any of the following as safety officer employees, so regional districts, government corporations, persons or bodies that operate educational or health institutions, or indigenous governing bodies. What prerequisites would the LG be looking at before prescribing those categories that are in those subsections?
Minister.
Thank you, Honorable Chair. So, and I thank the member for the question. So Bill 17, because these amendments are scattered throughout the bill, places obligations on the employer of safety officers. And what we would do would be to assess whether or not the proposed employer could meet the duties that are outlined in the Act, and is it in the public interest that they should be providing public safety officers.
Member.
Thank you, Chair. Appreciate the answer from the Minister. Which takes me to the next section under 74.4F. Talks about the powers, duties, and functions of safety officers, including without limitation the regulations to do any of the following. But it gets into FII, prescribe the law enforcement services that may be provided. And I'm reading this as a safety officer to provide the law enforcement services that may be provided, including without limitation in relation to the enforcement of the criminal law, the laws of British Columbia, the bylaws of a municipality or regional district, or the laws of an Indigenous governing body, the maintenance of law and order, and the prevention of crime, and the care, custody, and supervision of persons held in custody. So to me, this looks like it's back to a enforcement officer. So I'm just wondering, are safety officers now going to be required to have the training to conduct criminal investigations and all of the things that are required in here? Would they have to go to the JI?
Minister.
Thank you, Honorable Chair. Yes, they're going to have to be required. They are going to have to be required to take the training that's necessary to fulfill their duties.
Member.
Thank you, Chair. I guess maybe, when I was looking at the safety officer concept earlier on, and I could see the reason for it, because there was an absence of coverage for safety officers when it came to coverage and IIO investigations and those kinds of things. But the description of the duties here indicate that they're almost a full-fledged police officer or an enforcement officer. So I'm just wondering why the extent of the duties listed under the subsection F here. It's much, much more than a guard or detention, somebody looks after the cell block. So I'm just wondering what the minister's envisioning here, or why is such a broad definition for this?
Minister.
Thank you, Honorable Chair. So this sets the baseline for what they could do, and then later through regulation, we're able to narrow it down to what they will be doing.
Seeing no further questions, shall Clause 83 pass? Shall Clause 8, so ordered, shall Clause 84 pass? So ordered, shall Clause 85 pass? So ordered. On Clause 86, Member.
Thank you, Chair. Just a short question here, clarification. The external police service, it adds a definition of external police forces, or police service rather, in relation to a municipal police department, to which Section 89, so reporting death, IIO investigations and whatnot. But it has, as part of this, another municipal police department, the provincial police service, or a designated policing unit. And from our earlier discussions, designated policing unit in British Columbia is CFSEU? No. And transit is a designated policing unit. And the Lillooet First Nations band is a designated policing unit.
Minister.
Thank you, Honorable Chair. Organized Crime Agency, Statlium, and Transit. Those are the 3 DPUs.
Member.
No, thank you, Chair. So are any of those units providing this kind of service right now to the IIO or to these kinds of investigations?
Minister.
Thanks, Honorable Chair. Not trying to avoid the question, but because it's under the AG, you'd have to actually ask the AG that. We can endeavor to get the information for the member, though.
Member.
It's, I suppose at the end of the day, it's probably inconsequential. I'm just looking at the work that those particular units do and the demands that they have already to be called in to do something like this when there's other options. But it's just an option that the minister has, obviously. Yeah.
Shall Clause 86 pass? Aye. So ordered. Shall Clause 87 pass? Aye. So ordered. Shall Clause 88? Recognizing the member.
Yeah, thank you, Chair. Just need a little clarification on this. It expands the application of this particular section. Section 78(1) is amended by striking out a complaint concerning any conduct of a member and substituting a complaint concerning any conduct of a member or former member. I'm wondering if there's a definition of former member that the minister can provide.
Minister.
Thank you, Honorable Chair. It's the current definition that's in the current Police Act.
Member.
Excuse me. So I guess what I'm looking at, the expanding this to deal with former members, is it just restricted to what's in the Police Act, or is there something more that is intended with this particular section?
Minister.
Thank you, Honorable Chair. So, yeah, it hasn't changed. It's the same one, and it is, and I'll just read it. So, in relation to a complaint or an investigation under Division 3 concerning the conduct of a person who at the time of the conduct of concern was a member of a municipal police department, but who after that time has retired or resigned and is no longer a member of any municipal police department, means that person. Okay.
Let's try that again. Shall Clause 88 pass?
Aye.
Shall so ordered. Shall Clause 89 pass? Aye. So ordered. Shall Clause 90 pass? Aye. So ordered. Shall Clause 91 pass? Aye. Shall Clause 91 through 93 pass? Aye. So ordered. On Clause 94, inclusive. Shall Clause 94 pass? So ordered. On Clause 95.
Thank you, Chair. So this particular section authorizes the Chief Constable to designate a qualified person to be a discipline authority instead of the Chief Constable. It says at any time after an investigation is initiated under this part into the conduct of a member or former member of a municipal police department, the Chief Constable of the municipal police department may designate a qualified person to be a discipline authority instead of the Chief Constable. I'm just curious as to, so at any time, and I've seen this careful how I word this. So I guess I'll just look to Minister to define what any time really means here. Like from the moment the complaint is received, or sometime after that?
Minister.
Thank you, Honourable Chair. It means from the moment the complaint is initiated to the moment the complaint ends.
Shall Clause 95 pass? So ordered. Shall Clause 96 pass? So ordered. On Clause 97, Member.
Thank you, Chair. So this is the section where the Police Complaints Commissioner could appoint a retired judge to exercise the powers and perform the duties and whatnot. A question that one of the staff brought to my attention here. Does the minister believe this amendment satisfies recommendation 24 of the 2019 Special Committee to review the police complaints process report? And why not make it mandatory for the Police Complaint Commissioner to appoint a retired judge as the discipline authority when the conduct of concern is or was a chief or deputy chief as per the recommendations in 24?
Minister.
Thank you, Honourable Chair. So the key reason is that because of the changes that we've made to who will chair the police board, the likelihood of a conflict of interest, if you like, is significantly lessened. They're not automatically the default disciplinary person who's dealing with it. So there's the ability for to say, you know what, if there is a perception, the Complaints Commissioner can appoint a retired judge.
Shall Clause 97 pass? So ordered. Shall clause 98 through 116 pass? So ordered on clause 117. Member?
Thank you, Chair. This is just a simple question, I guess. Looking for a definition of systemic. So this power of the Police Complaints Commissioner to investigate systemic issues, if I can get a definition of what that means?
Minister.
Thank you, Honourable Chair, and I appreciate the question from the member. So it's informed by the factors set out in subsection 2. And I'll just read them for the member. So A, the nature and the seriousness of the matter, the prevalence of the matter in relation to one or more municipal police departments, whether the investigation is necessary to preserve public confidence in the disciplinary process, and whether the director has studied or investigated a similar matter.
Shall clause 117 pass? Aye. So ordered. Shall clause 118 through 133 pass? Aye. So ordered. On clause 134, member?
Thank you, Chair. 134 is the transition appointment of council member to the Surrey Police Board. What's the planned date for the section to come into effect, and when does the minister plan in issuing the revocation order for Surrey?
Minister.
Thank you, Honourable Chair. So as the transition progresses, I'll obviously have discussions with the administrator and the Director of Police Services on the appropriate time for him to step down and for the board to be reinstated.
Member.
I think the question will be under the next clause.
Shall clause 134 pass? Aye. So ordered. On clause 135, member?
Thank you, Chair. And again, this deals with transition and the chair and vice chair of the Surrey Police Board. Would this be the former board, or is the minister looking at appointing a brand new board for Surrey?
Minister.
Thank you, Honourable Chair. So when the administrator was put in, the board was in effect suspended. There's a variety of terms on there. So at that time, I would have to look at which appointments are still in place and which ones have expired, and then look to make the necessary required appointments.
Thank you, Chair. And this is, I was looking through the transition and the commencements of this transition here. There's quite a list, and I'm just wondering if the minister can just give me an overview of how he's planned out the transition and why he's grouped the transitions the way they are, and how long it will take the full transition of these amendments to take effect.
Minister.
Thank you, Honorable Chair, and I appreciate the question, and I've got all kinds of stuff here. Anyway, and probably best way to describe is just to give the ones that are going to come in royal assent, and then others by regulation. So the chair of the board, vice chair with royal assent. Clarification on police budget approval process, royal assent. Board policy complaints, royal assent. Mandatory board training and board code of conduct will be by regulation. Expand the qualified discipline authority options, royal assent. Expanded definition of misconduct, royal assent. Earlier public hearings, royal assent. Systemic reviews by regulation. Misconduct observers by royal assent. New guideline making authority by royal assent. Constable reassignment in emergencies, royal assent. Streamlining the designating policing unit, designated law enforcement unit process, royal assent. Register complaints, royal assent. Police uniform requirements, regulation. Police force to police service by regulation. Clarify liability, royal assent. Safety officer framework regulation. Detention guard oversight regulation. And that my expectation is that the first of the regulations will start to come in the spring of next year.
Seeing no further questions, shall Clause 177 pass? Aye. So ordered. On Schedule 1, shall Schedule 1 pass? Aye. So ordered. Schedule 2, shall Schedule 2 pass? Aye. So ordered. Shall Schedule 3 pass? Aye. So ordered. Shall the title pass? Aye. So ordered.
Chair, shall the committee rise and report the bill complete without amendment?
Where am I? Oops. Members, the question is that the committee rise and report Bill 17 complete without amendment. Those in favor indicate aye. Aye. Those opposed? Motion is carried. This committee stands adjourned. We will need to be back in approximate at 25 to 4, please. Afternoon, members. I call Committee of the Whole on Bill 22, Safe Access to Schools Act, to order. Shall Clause 1, oh,
Chair, I'm just going to take the opportunity to welcome the team that's joining me here today.
very good.
I want to thank them for their work and for assisting me. It's Kirsten Fisher from the Ministry of Education and Childcare and Darren Thompson from the Ministry of Attorney General.
Recognizing the member from Vancouver Langara.
Thank you, Madam Chair, and I appreciate the patience of the Attorney General and the House here. I'm on what's left of an 8-minute recess on ministerial estimates and energy, so I'm going to start this process with the Attorney General and then step back out and complete that portion of the energy estimates that I'm in around mines, Mineral Tenure Act review, and then come back in, which means that I will at some point here turn it over to my colleague, the member from Coquitlam-Millardville, who will continue with the initial questionings around the bill. But let me just say this, that I know that the Attorney General hopefully had the opportunity to hear my remarks on Bill 22 during second reading, where I did spell out a number of different considerations for this bill. We aren't there yet, but one of them included the extension of the application of the bill as we see it by way of Lieutenant Governor and Council by regulation on access zones, determination of schools and class of schools. We will get to that in Clause 3 of the bill. In terms of Clause 1 and Clause 2 of the bill, Madam Chair, we will, at the outset of this bill, talk about the scope of the bill. I've talked about at second reading that want to understand from government, and perhaps that will be my first question coming up. I just want to introduce this a little more before I run out of time as to the purpose of government by bringing forward this bill, just to hear it directly from the Attorney General. She's already made her second reading speech and first reading as well, but I just want to be clear on this because the concern that we have raised is that it is quite narrow in scope. We all share the concern that the Attorney General spoke about for children and having safe access to school spaces. But we've also heard, myself and the member from Coquitlam-Millardville and others, have heard about the concerns from other parents and families for children in other spaces. We hear this from other ethno-cultural communities about their centers where their children go to preschool or have other educational activities. We know that in the case of other places of worship, faith-based gathering places where there's also religious education on a weekday evening or on a weekend or typically on a Sunday, depending on the religion. And so there is different types of educational activities that we want to keep our children safe in. And of course, we have, as the member from Coquitlam-Millardville has had a big focus on from her past work as a former minister for post-secondary, what's going on university, colleges, and campuses, which again are our children. And so with that in mind, Madam Chair, I do have, when we get through this discussion and when I'm back, we will have some discussion about how the bill might be strengthened to address some of these broader considerations. I'm sure the member from Coquitlam-Millardville will explore what that looks like and the need for that. So we go back to the original purpose of the bill and why it is specifically this specific, even in a Lieutenant Governor and Council by way of regulation kind of way, subsequent to the bill. I think if we can establish that basis, I will just say that at some juncture, with the help of the clerk to the committee stage here, there will be a discussion, given the nature of some of the amendments I'm considering here, depending on the Attorney General's responses. There is a bit of an interplay in terms of the definition section in Clause 1 versus the application of the access protected zones, the types of zones. Here we're talking about schools. So to the extent that we are able to continue broader applications of this bill, for the reasons that I'm sure the member from Coquitlam-Millardville will discuss further as I step out of the room in about 3 minutes. I will, let me ask the question first to the Attorney General. Can the Attorney General please confirm and elaborate upon why this bill has this specific purpose and why the bill, and I appreciate that, this is just evidence of my consideration around the time limitation on the bill. We'll get there in Clause 9. But I think it's helpful at the outset to know the government's approach as to why this government is bringing this forward at this time. What problem are they addressing specifically with this bill?
Minister.
Thank you, Chair. I think this legislation comes out of an unfortunate series of circumstances in the province. And everybody, I think, agrees, and especially parents, that when they send their kids to school to learn, that it should be a safe, welcoming place for them to do that they shouldn't be faced by intimidation or harassment, or they shouldn't feel like their access to the school grounds are prohibited, and parents shouldn't feel like they have to think about that when they're sending their kids to a school environment or an educational environment. And because of incidents that we've seen in the province, we felt like it was necessary to design a piece of legislation that was focused on students and young people that are very vulnerable, and their ability to access education, which is kind of a fundamental thing in society. And also, as I mentioned in my second reading speech, every time you step into limiting, we all operate under a constitution, and all of our laws need to consider that. So political expression is protected and constitutionally in our province and our country. So when we designed this legislation, we did it in a way that showed a clear objective to protect a certain type of harm through an access zone and particular characteristics in a time-limited way, and made sure to say, or as we always have to do, is that there are places where you can protest in a democratic society. But when we're talking about young kids accessing school, that should not be the place where they are faced with intimidation, harassment, or those kind of things that we were seeing. So that's really the purpose of the legislation. It's designed for protection in that regard.
Recognizing the member from Coquitlam-Millardville.
Thank you very much, Madam Chair. So I'd like to just follow up on that explanation. It was very, very helpful. And I wrote just down some keywords that the attorney commented on in terms of the context of this particular legislation. It was about kids going to school. They shouldn't experience intimidation or harassment, that they should be able to access an educational environment. This is about children being vulnerable and being able to access education, that this was repeated over and over, and I appreciate that. Does the attorney also agree that preschool children should be captured in that as a vulnerable population, getting access to education and being free from intimidation and harassment?
Minister.
Yeah, so just to the member's question, yeah, I think, of course, I think we would all agree that nobody wants any child to be harassed or intimidated in any way. Excuse me. In the context of this legislation, sorry. I'm losing my voice too. In the context of this legislation, it was structured and designed very particularly because of a pattern that was happening since 2023 on school grounds, and the evidence that it was affecting K to 12 students. But I mean, this type of legislation, which we used in COVID, is a way that we can step in to make sure that people can have a safe zone around something. And so the structure and the context of it is designed to address what we were seeing from K to 12 in K to 12 institutions.
Member.
Thank you. Thank you very much, Madam Chair. I appreciate the response. I want to follow up on that question around vulnerable children. I noticed that in the definitions, there isn't one about children. That there's no definition of children, and I want to speak specifically about children who are going to post-secondary institutions, where we are in fact seeing a significant pattern of intimidation and harassment. In fact, I have a letter that I'd like to read into the record from a parent whose kids are going to UBC, and what their experience. And again, you know, they're a child, they're under the age of 18. This parent says, last night I attended an event at the UBC Hillel House. It was a unique event to which parents, students, and siblings were invited. We were notified early in the day that a protest had been planned, that RCMP, campus security, and some private security would be at the event, and that ID would be checked at the door. When we walked toward the event at 5:15, we could see about 35 to 40 protesters outside on the public walkway, along with RCMP, campus security, and private security, which I was told Hillel House had organized. The protesters were marching across the entire walkway. When we approached the Hillel House, our path was blocked by them literally inches from our faces, screaming hateful language and refusing to move aside. Some of the chants were "From the river to the sea," "Palestine will be free," "Genocide enablers," and "Baby killers," to name a few. As an adult, I was extremely alarmed about where this could go next, but my daughter, a second-year student, and son, a grade 12 student, were visibly shaken. Only when I yelled to the RCMP, standing approximately 25 feet away from the demonstrators for assistance, did they approach and ask them to let us through. They did not ask them to clear a permanent path for the duration of the event or attempt any mitigation. Once we passed, the protesters stepped back into where they were before to block others coming in after me. It seemed as though the RCMP and campus security were okay with the protesters blocking our path and would deal only with the outcome of any confrontation. There seemed to be no plan or strategy for blocking us or the hate speech. After the event, we were told that we could not use the front door of the Hillel House to exit because it was too dangerous. The RCMP, campus security, and private security endorsed this. The RCMP told us that there was nothing they could do and that they were outnumbered. The campus security said we could get hurt if we went out the front door. I can tell you unequivocally that my daughter felt extremely unsafe yesterday, and she commented that if I were not with her, she would not go back to another Hillel event with a demonstration without an escort. As a student, she was physically and verbally intimidated. Further, if this is the atmosphere at UBC, there will undoubtedly be a factor in our decision of where our son attends. There are a number of other sort of responses from UBC and back and forth from this parent. UBC certainly doing their best to assure the parent that they had full control, but we have seen this again and again and again, a pattern, as the attorney just detailed. And we know that children, 17 and 18, do attend university. So is there an intent at all to expand the scope of this beyond K to 12? Given the desire to protect children and those who are vulnerable from intimidation and harassment, using the attorney's words, and adjusting this legislation to include public post-secondary schools in the province.
Attorney General.
Yeah, thank you. I just want to start out by thanking the member for not only her passion on it, but sharing stories that I know are things that, even though they're hard to hear, we all do need to hear of what's happening and what people are experiencing in this province. I can only imagine that that young child went home and is probably still upset about it. So I just want to maybe talk a little bit about the process of doing access zone or bubble zone legislation. It is the way that you have to approach it legally and legislatively is think about all of the powers and structures that are in place and what you're balancing, because you're always going to have to balance constitutional rights with the rights of the management and authorities of that institution or that area. So when we did it for hospitals in COVID, we had to design it keeping in mind the Hospital Act and all of the managements and all the things associated with that. So this legislation very particularly is grounded in the School Act, the rights, I guess, or the situation of young minors, so K to 12, operating in a school environment, and the requirement of them to go to school, and all of the ways that we could think about structuring a protection that balances constitutional rights of protest and sets out very specific behaviors that we were seeing through the evidence that were happening, and establishes that access zone of 20 meters. It is very targeted as a tool, and it's structured under the legislative and management structures that are around in that situation. So in that context, post-secondary is legislatively and in many ways quite different than the school environment, not only in the acts that, and I know the member knows this, but in the acts and the management of the authorities of academic world and everybody that exists on university. So you would have to, I guess I would say there should be, and there are tools to address, and they should be used to address the type of intimidation that the member is talking about, and that's an important conversation. But this particular tool is very much structured around the K to 12 post-secondary, or sorry, a school environment, and it's because of that, as I described, the balancing act you always need to have when you're creating an access zone in the context of freedom of expression.
Member for Coquitlam-Millardville.
Thank you. Thank you very much, Mr. Chair. So I appreciate the legal challenges as the attorney just expressed. And so she speaks about that there should be tools. Well, I think it's important that you know that there aren't tools that are being used, and I would hope that the attorney would be exploring what tools can be used, given her passion for making sure that people have access and that people are safe and not feeling intimidated and harassed. The attorney did speak to the fact that it's the pattern that is the problem, and which is what brings this legislation to the floor right now. And frankly, I haven't heard more recently about any ongoing issues in the K-12 sector. Perhaps the attorney can enlighten where it's currently happening and why this legislation needs to happen now, given that I haven't been hearing what's happening there.
Attorney.
Thanks. I appreciate the question. It is unfortunate that it's still happening. There was one as recently as April 16th, 2024, in Surrey, where protesters harassed a grandparent that was picking up a grandkid from school. And they followed the grandparent actually to his or her house afterwards. And then again on April 9th, there was a protest outside of a school in Surrey. And they were chanting things and waving signs about anti-SOGI messaging. And there was one on April 4th in Surrey. And I have a long list, unfortunately, of when they are happening. And we were hearing from parents, in particular, that the experience of dropping your kids off and having that and worrying about what adults were going to do to intimidate them, and some of the signs that people were posting were pretty offensive, like no child is born in the wrong body, girl cannot be boy, boy cannot be girl, and these were things that kids were seeing. as they were, and that was like in April of 2024.
Member.
Thank you. I appreciate that that the attorney is tracking this very closely. So, given that those signs are hurtful and intimidating and harassing, what does the attorney recommend, or how does the attorney think about these sorts of acts happening in places where children are known to go to a more informal school, whether it's a community center, a place of worship, and does she believe that those children deserve to be protected from these sorts of messages as well?
Attorney.
Okay, thank you. So I'm just going to dive into the legislation because I think it'll help explain how this is constructed. So first of all, it's content neutral. So I think it's important to understand that although the list that I mentioned before was about specific protests that were anti-SOGI, it will cover any kind of protest, intimidation, harassment, blocking of access. And the definition of what, and this is what I was talking about, we dug into schools. So the definition of what is how it's, what types are under the definition of education authority under section 1. And there's a list of education authorities there. And so it's bound by that. And then the next level of that is that independent school authority, a school authority can be a range of schools, including the Guru Nanak school, the Jewish Day School Society. These are education authorities, and the BC Muslim Association. So there's a range of them. I think there's a whole list of them under the Ministry of Education that are under that. So then you've captured a content neutral kind of thing. So it could be any kind of intimidation or harassment. And then you have a list of independent schools that could include those range of schools. And the authority then, I think the third part of it is the regulation power that comes in this bill, gives us the authority as government to monitor what's happening on the ground. So let's say there is a particular unfortunate spike in the types of behaviors that we don't want to see around educational authorities and some of the independent schools, then we could design a regulation that creates an access zone around that particular place. And so it helps us be able to just address situations as they arise under the context of the tools in the bill.
Member.
Thank you. I appreciate the explanation. So I have some more questions just around which children going to which institutions will be covered by this and protected by this, actually, because I agree that we need to protect children. And so if your child goes to before and after school care, or if they're a preschooler and they go to childcare on a school site that's listed here, then they will be protected. But if they go to a preschool and they get all the government funding, the same government funding, it's the same support, but they're a not-for-profit, for example, in a rec center or in a community center, they are not protected in the same way. And so can the attorney explain to us how there's this commitment to protect children who happen to go to before and after school care or early learning programs in one of these institutions that's listed, but if they happen to get the exact same thing, but they happen to attend in a different institution, how they don't get they don't deserve the same protections?
Attorney.
So I'll start by saying, absolutely, everybody wants to protect kids wherever they are. I'll say that if the preschool and after-school care are on school grounds, and you have to remember the broad definition of school grounds, that could be from an independent school or the Guru Nanak, if they are on school grounds, then they could benefit from an access zone if that was something that was seen that we needed to put in place. When this when this legislation was designed, we saw a pattern at K-12 schools that we were trying to address. I mean, I think we need to monitor. Obviously, we want to step in where there's need. If there's a similar pattern in other places, first of all, we should figure out what tools we have to address it, and then if it's needed that we need to step in other ways, I think we should be open to that.
Member.
Thank you. I appreciate that. And again, I did highlight the fact that there are lots of programs that exist outside of school grounds. And if I understand the attorney correctly, she's prepared to monitor to see if something needs to be done. However, I think given that we have legislation before us and to not act in the moment, for 6 months, I will say the Jewish community has been targeted, and we see it over and over and over again. And I don't know what the attorney is waiting for in order to take action, but there is certainly some concern. And I'm happy to read into the record additional acts. There were, and I know that this covers Tamatora. There were 2 separate individuals who were arrested after targeting Vancouver Tamatora in October and November of 2023. The first involved an individual going to the school multiple times to make anti-Semitic statements and gestures, including a Heil Hitler salute. 2 disruptive demonstrations targeted Hillel House at UBC, including by the Revolutionary Communist Party that blocked access to a March 13th event on Jewish culture. We are seeing, according to the Vancouver Police Department, anti-Semitic hate incidents rose by 62% in 2023 compared to the previous year. The community, there's considerable cost to law enforcement agencies like the VPD, who spent $2.5 million in overtime costs just to staff protests related to the Israel-Hamas conflict. Recent polling release shows that 72% of British Columbians are worried about protesters targeting Jewish neighborhoods and Jewish-owned businesses in Canada. So I do think there is a pattern that I think is undeniable. And I don't know what the attorney is waiting for, because we are seeing a pattern. And I would have hoped that perhaps in this legislative session, there had been some legislation to protect those particular institutions that are being targeted right now. And waiting till next January, I don't think would help in any significant way in the moment. So I am hoping that she can see her way through to perhaps considering an amendment that would make sure that those other institutions that provide services to children are protected as well. I do want to come back to public post-secondaries, if I might, because I want to go back to the explanatory note. And the explanatory note in this bill says it protects access to schools by authorizing Lieutenant Governor and Council to establish access zones around schools and prohibiting protests and other conduct in those zones that impedes access, disrupts provision of educational programs or extracurricular school activities, or causes concern for a person's physical or mental safety. And when I read this, I think about access to classes in public post-secondaries. I think about educational programs. And I hear, and I did read into the record a particular story at UBC. There's another one I have from Langara where a Jewish student went to the washroom, and while she was there, a protest erupted, or was planned, but it did erupt from her perspective in the hallways of the school, inside the school, to the point where she was afraid to exit the bathroom for 20 minutes, and she missed her class because she was afraid for her safety to enter into a protest that intimidated her, harassed her, and made her feel very vulnerable, to the point where she missed her class. And so again, impeding access. The attorney believes that the institutions somehow have tools, and I'm wondering if she could, and I know she may not have the staff here to let us know what those tools are, but I'm hoping that as the attorney, she has some familiarity with what tools public post-secondaries might have, and if there's a gap, what she's planning to do around the gap, so that those children can also have access to the education that not only they're entitled to, but that they've also paid for.
Attorney.
Okay, I thank the member for the question, and I do appreciate that this piece of legislation is not the only tool that we have, nor should we use to combat anti-Semitism and all forms of hate in the province. And the member listed specific examples of where it's happening and where she's seeing it and the community is feeling it. I just wanted to say that this tool will assist because the Talmud Torah, as an independent association, is listed and would be part of this. So you could conceive of an access zone around a place like that so that the kids that are going there would not have to face similar things that she mentioned. So the other thing that I would say is that acknowledging that we have to have many tools to combat hate in this province, and I think the different places that the member said that people are experiencing, it requires different tools. And I think as a government, there are different things that we have changed or done, including updating the hate crime policy to specifically say anti-Semitism, or has resulted in a charge. And we always need to do more, including stepping up. But I think meeting with the special envoy yesterday, where we had a good discussion about how tools like what we have on the anti-racism bill that's also before the House could be another avenue, and we were going to work on that to make sure it specifically includes anti-Semitism, but there are tools in there, add a whole bunch new to our toolkit for addressing it, like, for example, holding the public service accountable for mandatory training or training for public bodies when it comes to understanding that. And I think we had a commitment to work together in terms of anti-Semitism specific ideas that we could do with that. The racist incident helpline, like speaking specifically about what anti-Semitism looks like and is showing up in, and how we can use that tool to reach out to communities and help to understand that. Police training that we're going to be investing in. There are going to be two sessions in Victoria and Vancouver to help frontline officers understand what hate crimes are like and how they show up and how they can actually, I hear a lot of times that I report it to the police and I'm not sure what happens. So getting that on frontline training for people to understand that, how it is. I recently wrote to Minister Varani a while ago now to say that I think we need updates in the criminal code, specifically about hate and anti-Semitism. And I can happy to provide the member that information of the things that we're pursuing. I think that there are, and then the security funding, I know there's so much more we could do, and we're always thinking of ways to step that up, because it is disturbing to hear the stories, and I share that concern with the member. I just wanted to say, with respect to post-secondary, the post-secondary institutions, and I know the member knows this, are governed under the University Act and the College and Institution Act, so invests the powers of the management and administration control of the property to the Board of Governors. So it's just situated legally differently than the way what this legislation is targeting. And so I think and I'm very happy to do this, to sit down with the Minister of Post-Secondary and speak about like what are, I don't know the tools right now because I'm focused on this, but I'm happy to sit down with the member and the Minister to try to like think about what are ways we can help with the people that are facing this stuff in post-secondaries.
Member.
Thank you, and I'm pleased to hear that the attorney is interested in meeting with the Minister for Post-Secondary Education because I was supposed to get a briefing and I never got one when I was the Minister of Post-Secondary Education around what we're doing around, what the government was doing around anti-racism and hate in the community. So I'm glad to see that she's finally paying attention to that. The Minister mentioned Talmud Torah, and there's a number of private schools, religious schools, in the community, and not all parents can afford those tuition fees or choose that, and so there are other places where they might send their children for a Jewish education, like the Jewish Community Center or their synagogue, and those children can be exposed to this sort of hate, intimidation, and harassment. And I'm just wondering if the attorney has turned her mind to consider expanding in a very limited way, particularly while the hate is so virulent. And I appreciate that the attorney has spoken, again, finally with the special envoy. I had been in touch with her weekly since November, and had regular conversations about what needs to happen. And so I'm pleased that she and the Premier both met with her, I think, finally yesterday. And I know we're also not alone here in British Columbia, that they're dealing with this in Ontario and in Quebec and in other places. So I'm wondering if the attorney has had any conversations with her colleagues across the province to look at expanding this notion to places of worship and ethnocultural centers, more broad-based, given the fact that we are seeing such a significant pattern of hate that has been going on for 6 months. And I don't believe that we should be waiting much longer to address that. And I'm wanting to know if she's had the opportunity to consider that and talk with her colleagues across the country.
Attorney General.
Thanks. So, yeah, I'll just start by saying that as we canvassed before, this legislation is an added tool, it's particularly for K to 12 in all of the schools, including one of the ones the member raised for protection of youth. And that includes protection against anti-Semitism that might show up on those schools. So it is an added tool. And I think it's unfortunate that we need to have it, but it is an added tool for that. Another one of the questions that she raised was whether or not I meet with counterparts. There's a few ways we're connecting. So one is generally different attorneys generals have met, I think, a few times on hate and combating and the rise of hate in Canada, and that unfortunately comes from different communities at different times. And a lot of the data says consistently that it's the LGBTQ plus community that is experiencing, like, consistently over the years, the highest spike in hate incidents. So we collect that data, we understand it, we work together on policies, and it's one of the reasons that I wrote Mr. Varani about specific changes on hate a while ago to the criminal code. I also want to say that with respect to religious institutions, I've had different religious groups approach me and speak about whether or not you could amend this legislation to add religious institutions. And it was something that my team really looked at, like, is it possible to do this in a way that protects those kind of concerns and makes amendments? And we came to a realization that it's not a simple process because not possible because this bill is very specifically designed for K to 12 and kids. And all of the authorities in the act, similar to the argument I said about post-secondary institutions, it wouldn't be something we could do. But I'm actively thinking and listening about ways that, there could be other work with respect to that. And I'm open to discussions about that also, but just that this tool is for K to 12, is content neutral, so includes all kind of intimidation, harassment on that, for that population, which I think we all would agree that needs to be protected the most when it comes to any kind of hate or intimidation or things that they might see when they're going to school. I think that was another question. And I just want to reiterate that this is not the only thing that we are doing. And I could stand here for a long time about the work we've done over the last many years about anti-racism and changing systems that work better for people. And it's really important work. And there are new tools that government's never had in the anti-racism bill that's before the House right now that will help us remove systemic racism. It includes anti-Semitism from all of our services and hold government account to that. When I spoke to the special envoy about some of the sections in that bill, she said to me pretty directly that that's very innovative and BC will be a leader in a lot of ways through that piece of work. Unfortunately, hate has consistently been on the rise for different communities in different ways, and we always have to be receptive of the specific needs of each community, but we also need to just establish systems and tools that help to combat it in a government-wide way, which I think we are doing in different ways, and will continue to do. So this is not going to answer everything, but it's going to protect K to 12 students in a whole range of institutions, including Jewish schools that we've seen incidents of anti-Semitism, and it's going to give us regulatory powers to be able to adapt if we see spikes in certain areas and create access zones so parents can know that their kids will not face that when they go to school.
Member for Vancouver-Langara on Clause 1.
Thank you, Mr. Chair. It's a pleasure to join my colleague, the member for Coquitlam-Lordville, back on this bill. Thank you for carrying the debate discussion today. And I want to thank the Attorney General from the opening exchange I had with her for her openness to have this discussion at the front end of the bill on Clause 1. I will acknowledge that the Attorney General has referred to another very important bill, Bill 23, that is another bill that she's introduced to the House, and we look forward to have the opportunity for a fulsome discussion around that bill too. But I do appreciate, as the Attorney General is demonstrating, that there are a number of initiatives that the government has brought forward in this area, and that's the reason why, again, I appreciate the openness to discuss this particular initiative, this instrument, and the application of it. And the member from Coquitlam-Millardville has covered a number of the different areas that I also wanted to speak to as well. I've had the opportunity to get a brief update from her as to the minister's responses, the Attorney General's responses. So I believe that my next series of questions and exchanges and the time we have left for today will now hopefully not repeat or be redundant. I just, on the point that the Attorney General just made in terms of other religious institutions, and again, Mr. Chair, at the front end of the bill, we're covering particularly the scope and application of the bill. So that's the reason why we're having the conversation on Clause 1. We recognize that there are access zones that are specific to schools on Clause 2. So there is again a bit of an interplay between Clause 1 and Clause 2. But as I said at the outset, when there was a different chair in the seat, I am considering with the member from Coquitlam-Millardville and other members here, other colleagues, ways to strengthen the bill. And that's the reason why the member from Coquitlam-Millardville has been talking about some of these areas. Just on the particular response about religious institutions, though, just for clarity, Mr. Chair, I've also heard from religious organizations, religious community organizations that have asked the question, can we strengthen the bill, the School Act, the Safe Access to Schools Act? And I will say and note that the Attorney General is bringing forward this bill. It's not the Education Minister relating to the Schools Act. So clearly, there is a concern relating to, as the member from Coquitlam-Millardville pointed out, the explanatory note. I think it provides a good description of the purpose of this act, which was my first question. I understand that the Attorney General in response talked about vulnerability, talked about intimidation, talked about threats. And obviously, we're talking about children. So when we're talking about children who go to religious institutions and places of worship for religious education and instruction, or some other schooling activity, which by the by, Mr. Chair, does include, there are points in this bill that refer to extracurricular activities as well. So it doesn't have to be strictly, education is, of course, comes in many different forms, not just academic. When I look at some of the incorporation by reference of the independent school definition, though, or is there? The bill makes reference in Clause 1 to the independent school authority. And so if you look at that definition, Mr. Chair, I'm just wondering how the term independent school might come into this bill. Perhaps the Attorney General can assist me in that. We're referencing independent school authority, which I know is referred to under education authority. So education authority, of course, comes into the definition of school. So a school under this bill means a facility or part of a facility operated by an education authority, which means, in this case, by Clause 1, independent school authority includes independent school authority, putting aside some of the other entities, including our First Nation. When I look at the Independent School Act, though, to the question from the minister, from the member from former minister, the member from Coquitlam-Millardville, a school, the independent school definition includes a school that solely offers religious instruction. So my question to the Attorney General through you, Mr. Chair, is this. Does the independent school definition from the Independent School Act, which is referred to as by reference by the Independent School Authority, is it brought in to the application of this bill? And if so, does a place of worship like a mosque, like the one example I've been using on second reading in this bill, which I know many members, I've stood on the stage with many members of the government, including the House Leader, at the mosque on River Road in Delta. That particular mosque has facilities for educational instruction. I don't know offhand whether it's just religious instruction. I would think it's obviously religious instruction, but perhaps it's other instruction. Does a place like that fall into the application of this bill?
Attorney.
Okay, so I'm going to turn to the statutory construction of the bill to explain the answer to this. So the first thing to look at is the definition of school. It means a facility or part of a facility operated by an educational authority at which student receives instruction in an educational program. So if we break down that definition, the first thing to look at is educational authority. So educational authority, the definitions that's provided earlier on educational authority, includes an independent school authority. And under that, a list of that would be things like the BC Muslim Association, because the member raised a particular institution. So if the BC Muslim Association is operating as an educational authority, an educational program in a facility or part of facility operated by the educational authority, then it could be captured by this access zone. And so hopefully that explains the structure of it. We would have to look honestly at the very specific circumstances of the cases to verify that. So I don't want to, but if you understand the construction of what we were looking at, I think it shows what's included.
Member.
And I appreciate the response from the Attorney General, and perhaps this is the reason why. I think the reason why the Attorney General is the one who's the lead minister on this bill is presumably around public safety to vulnerable peoples, our children, in schools. Because again, I will note again that this is not a bill that's been introduced by the Minister of Education, the minister responsible for the School Act, K-12. So when myself and the member from Coquitlam-Larville ask about university colleges and campuses, and I don't think I'll have the time to further the question around Langar College, which of course I have also a very direct experience in talking to the leadership team at Langar College and the leadership of the Jewish community in what happened to that unfortunate student and what is happening with student protests or other protests on that campus or off that campus. There's a whole discussion that we should have there, but I just would say to the Attorney General, as we continue the bill review at committee stage on this bill, that this bill clearly has identified a particular area of jurisdiction, which is the School Act, but clearly there are other areas of great need, urgent need, whether it's the last 6 months or something longer than that. So this is the reason why we continue to come back to the application of the bill and how it could be potentially strengthened. Coming back to the consideration, as the Attorney General acknowledged, inquiries from religious organizations and institutions, just to walk further through that interpretation and application. When I look at the authority definition under the Independent School Act, and again, this is an area where the Minister of Education, of course, would have great familiarity. The Attorney General and her staff and myself as the critic for the Attorney General may have less familiarity with these acts, but when I look at them off the shelf, I see that authority means a society within the meaning of the Societies Act, pretty broad, a company within the meaning of the Business Corporations Act, broad, a person designated by regulation as an authority, so check on that. Is the BC Muslim Association or the Khalsa Diwan Society for the Ross Street Gurdwara or this other Muslim mosque that I'm speaking to in Delta, for example, are they a person designated by regulation as an authority? I don't know. I would like that confirmed. That operates or intends to operate as an independent school. So the independent school definition then gets us into a school that solely offers religious instruction. So I think it's possible. The Attorney General said earlier that, and this is the reason why it's important to have this discussion, because before tabling any amendments to this bill, which we are currently considering and I do have in my possession, it needs to be refined. I want to make sure, of course, that the amendments that we propose are reasonable amendments, as they say. The Attorney General indicated that her response to religious institutions were, well, that may well be beyond the scope of this bill, and I need to reflect on what she said in terms of, we'll look at the Hansard transcript, but I actually see a path here. when I look at it, because it's, a school is defined, or an authority is defined pretty broadly. Any society, which could be a not-for-profit society, for example, under the Societies Act, that operates or intends to operate as an independent school, which is a school that solely offers religious instruction, can be viewed to be an authority, which is an independent school authority, which gets us back into this bill. So, this is the reason why I raise it, and I think that in the time that I think we have to rise for royal assent shortly, but I do think it's an area or question that perhaps I'd ask the Attorney General to take away to confirm with the Ministry of Education, because I do think it's an important area that we'd like to pursue. I will note that the school definition under the School Act is different. So the definition of school under the School Act is very different from the definition of authority under the Independent School Act and the one that's defined under this Bill 22. So hence the challenge to ensure that we are making sure that there is broader application of this bill. I think I'm suggesting and thinking that there is broader application. The Attorney General has already responded, it seems like, to religious organizations that it doesn't have that broad application. So I do think it's very important, Mr. Chair, that we do have a clear understanding of this, and the Attorney General may want to respond now, or we may need to pause the process, but I'll leave that in your hands, Mr. Chair.
We don't. Attorney General, noting the hour.
Respond later then. I move that the committee rise, report progress, and ask leave to sit again.
Members, the question is that the committee rise, report progress, and ask leave to sit again. Those in favor? Any opposed? Motion carried. This committee stands adjourned.